Hi, everyone. Thank you for logging into our webinar today. My name is Laura Prendeville. I'm a Senior Associate on the Insurance and Risk team here at Mason Hayes & Curran. And I'm delighted to be joined here today by my two colleagues, Richard Hogan, Senior Associate, and Sarah Burns, Senior Associate from the Insurance and Risk team. I might quickly just ask Richard and Sarah to give a quick summary of what they intend to discuss today. We'll start with you, Richard.
Thanks. Between myself, Sarah, and have a good few topics to get through in the next 50 minutes or so. I want to have a brief look at the Occupiers Liability Act and kind of discuss what is an acceptable level of danger or risks that can be on a property, and when can you successfully argue that a plaintiff simply failed to take care of their own safety and be responsible, and that was the cause of the accident. Going to move on to have a look at the personal injury guidelines. I know they've been discussed a lot, but new draft guidelines have been published, so we need to have a little look at that and see what could be happening in the year ahead with them. Then I want to discuss some stats and trends. I know we all want to hear about that, but what is happening in the field of personal injury litigation? Are claims going up? Are they going down? What's happening with high court litigation? So a couple of interesting reports were published last year, so we'll look at the highlight of those. And then last week, the Dillon case was in before the Supreme Court. So we just kind of mention that and what to look out for in the year ahead with the judgment coming down the tracks.
Great. And Sarah, what about you?
Yeah, thanks, Laura. I'm going to discuss defamation claims, specifically retail-based defamation claims. We're going to look at some defences available to these types of claims, some case law that was before the courts last year, and some changes that might be coming down the tracks in the next year or so.
Great. So over the last year, there's been a lot of really interesting developments in the area of litigation. So the purpose of the next hour is to run through some of those more interesting aspects and to discuss further trends that we see as key areas to look at for 2025. As a summary of 2024, it kickstarted with PIA rebranding to the Injuries Resolution Board, and they rolled out mediation services for certain claims. As Sarah said, our team have dealt with a significant increase in retail defamation claims. So we'll discuss retail defamation in a bit more detail, and we'll also touch on the Defamation Amendment Bill. The landmark Supreme Court decision of Bridget Delaney confirmed that the guidelines are here to stay. And towards the end of 2024, we saw the publication of the second edition of the guidelines. So we'll discuss those in detail and I suppose have a look at any increases on those. Data breach claims have been a hot topic since the GDPR was introduced in 2018. And our department has seen a significant increase in data breach claims over the last couple of years. In 2024, you can now bring a data breach claim in the district court. Before that, you could only bring claims in the circuit court and the high court. And obviously that has a really positive impact on costs in defending these claims, because it's district court costs, I suppose, as opposed to the circuit court or high court costs that we were once dealing with. And a lot of 2024 was spent debating the concept of non-material damage in terms of data breach claims. So we will have a look at that later on, as Richard mentioned, with the Dillon case. We've seen a number of really positive decisions in the area of occupiers liability, and we'll get to that in a minute and have a discussion about some of the more interesting cases in that area. And we've also seen the publication of two interesting reports dealing with periodic payments and the discount rate. And I could get into that for the next hour in detail, but we won't do that today. The report on the periodic payment orders recommended a revised formula to, I suppose, bring the figures more in line with wage inflation and economic conditions. Hopefully, the new government will implement those recommendations and we'll see some traction being gained with the use of periodic payment orders for catastrophic injury claims. The discount rate was seen as acceptable, so there's probably going to be no change to that for the moment, I guess. A full analysis of these topics and more was recently published in our Insurance and Risk annual review, which was published last week. We're going to pop a copy of that into the chat box for anyone that didn't receive a copy, in case you're interested in reading that. So let's kickstart the 2024 review in the area of occupiers' liability. And I suppose there were a number of legislative reforms in 2023. So there's no need to go in detail into the Act. I'm sure you've all been to webinars about that topic already. But just as a brief background, I might ask Richard to just give us a summary of what those reforms were.
Thanks, Laura. I think anytime I talk about the Occupiers Liability Act, it's important to remember there's no obligation on an occupier to remove all risks or dangers for visitors or recreational users on their property. Indeed, the burden of proof is with the plaintiff to show the occupier has breached their obligations. I think it's always an important starting point when you're looking at this, and probably doesn't always feel like that when you're a defendant in a case, but that is always important to bear in mind. So what the Occupiers Liability Act does say under Section 3 is that an occupier essentially has to take reasonable care that a visitor to the property doesn't injure themselves due to some danger on the property. When assessing that duty of care, or whether there's been a breach, the court can be cognizant or be aware of what's the reasonable care visitors should take for themselves, not to injure themselves in a property. Section 4 of the Occupiers Liability Act deals with recreational users and trespassers. And recreational users, someone using maybe a sports field to play sport, or even for a nature walk, or visiting a historic building, where it's a non-commercial activity. And that's at the lower bar or duty of care. And that's really not to act with reckless disregard that a recreational user will injure themselves on a danger on your property. And as you mentioned, 2023, around July, a number of changes to the Occupiers Liability Act were put on a legislative footing or were made. And essentially, these put onto a legislative footing previous decisions by the court. So, I mean, there's nothing new there. We can have some idea how it will be done. These changes, how the court assesses whether there's been a breach, whether an occupier has breached the duty, be it under Section 3 or under Section 4 for the recreational user. And essentially, the test is that was there a probability of a danger existing on a property? Was there a probability that danger would cause an injury? What is the probable severity of the injury? What were the practical costs of getting rid of that danger? And then essentially step back and what's the social utility of the property? Essentially, that's something that you don't have to remove every danger. You don't, if there's a low risk of something causing an accident, or the accident's going to be a small accident, you don't spend a huge amount of money removing it, essentially. So, I mean, that's putting a common law decisions on a legislative footing, which is very helpful. So we'll have to see how they start now being interpreted by the courts again.
Yeah, exactly. So as we said, there has been a number of really interesting decisions over 2024 in this area. And while they were decided on the old Act, it's very clear that the courts are giving serious consideration to balancing the rights between occupiers versus entrants. Did you come across any particularly interesting cases that you want to discuss?
Yeah, I mean, there's two cases really that jump out at me. We'll take Scanlon v. McDonald. That was a case involving a couple who were on holidays. They were down in Kerry on a camping holiday. They set up their caravan on a campsite. They were given a plot. I suppose the background, the plot they were given to set up was a little bit larger than some of the other plots. Not sure how familiar you are with campsites and camping holidays, but they had to connect the caravan into the mains. The extension lead didn't reach the mains. They had to borrow an extension lead, further extension lead from the owners of the campsite, and they hooked up the caravan. And then the plaintiff was getting some water from a tap. She crossed this cable, and unfortunately, she tripped over it and broke her arm. The plaintiff's engineering evidence was essentially that this was a trip hazard, a cable on the ground, which is pretty fair enough. I could trip over a cable. But it was critical that the size of the plot where the caravan was parked was too big. The distance from the caravan to the power point was too long. And this created a hazard that should have been removed by the occupiers, the owners of the caravan park. And just say this is brought under Section 3 of the Occupiers Liability Act, this claim. The plaintiff's engineering evidence was that this was very common practice in caravan parks up and down Ireland and throughout France and Spain. The caravan had to be connected to the mains. It was accepted the plaintiff didn't plug it in, but she was aware that this cable was there. She'd been on plenty of camping holidays before. And In coming to this decision, the court revisited this concept of a usual and unusual danger. It's been around for a while, this idea. A usual danger will be something like a stairs in a building is the example. We're all aware that a stairs can be dangerous. We can all slip and fall. We can all take reasonable care to prevent that accident happening by holding the handrail. And using the same analogy, an unusual danger might be a broken handrail or a missing step on the stairs. And in that case, an occupier needs to do something to remove the danger, remove the risk, or warn users about it as well. And what I thought was great, a kind of a practical decision. The court said, look, in this case I was discussing, Scanlon, a cable in a campsite, it's quite usual. The plaintiff should have taken reasonable care not to trip over it. It's a usual danger. She clearly didn't take enough care, and the defendant was successful in that case, and costs were awarded against the plaintiff.
You mentioned usual danger there. I think last week there was a Court of Appeal decision dealing with the concept of a usual danger. You might
There was, we put him in the spot, but yeah, no,
straight off the press.
Straight off. There was. In this case, the plaintiff fell over a curb. The High Court found in her favour. I suppose the background of the case very quickly. It happened at a Circle K petrol station in Sandymount, just beside the beach there. And it was early in the morning. The plaintiff drove and got herself a cup of coffee. She was walking across the road to the beach thing to watch the sunrise. And the evidence was the footpath in front of the petrol station was blocked with merchandise, fuel, logs, whatever the petrol station was selling. And she was forced to walk to the car park. And in the car park, there was a curb denoting the end of the car parking spaces. And she tripped over that and she fell over. Brought High Court proceedings. High Court found in her favour. They said the footpath shouldn't have been blocked. The engineering evidence was the curb, plaintiff's engineering evidence was the curb should have been painted differently to make it stand out, or there shouldn't have been a curb there at all. It should have been a gentle slope. I think really interesting by the Court of Appeal when they looked at this, said firstly, look, curbs are up and down the country. You don't need engineering evidence to assess whether a curb is a usual or non-usual danger. They said it is a usual danger that in all probability the plaintiff had been to the petrol station before, she lived nearby, she parked her car there, she should have been aware of the curb, and she should have looked out for her own safety. And the High Court decision was overturned and the defendants were successful in defending that case.
Yeah, I think that's a really helpful case. I certainly have a few cases on my desk at the moment that it might come in handy for.
Yes, I mean, there are a number of nuances in the judgments, it's a broad strokes of it.
So it's great to see such a common sense approach being taken by the courts at the moment in these kinds of cases. So that's the concept of an unusual or usual hazard. You'd also discussed the idea of a unavoidable risk when you were explaining the Act. Do you have any cases to give us an example of that?
Yeah, Laura, I mean, as I said, there's no obligation to remove all risks. I mean, that bar is just way too high. Was an interesting case concerning recreational users and that section 4 and that lower threshold, and looking at the ideas of social utility of a premises, was a case from Limerick. It was a Hickey, Limerick County Council and others. There was a child, 9-year-old boy, was playing in the playground. He was climbing along some monkey bars. He slipped and fell, and again he broke his arm. The plaintiff's evidence and the engineering evidence, which a lot of these cases may turn on, the engineering evidence was that the monkey bars were a risk, were a hazard, and they weren't captured by the relevant EU safety standards, and they posed a risk because of the shape and the way they were designed. There was no issues with the ground in the playground. That was the appropriate soft kind of ground to absorb the fall. At the outset, it was heard before Justice Marguerite Bolger, and she again repeated what is kind of settled law. We all understand that playgrounds for children are risky. They produce hazards. Children can fall off slides, off swings, off monkey bars, and there's no obligation to remove that danger there. Inherently, there is a risk there. The benefit of them outweighs that risk. The social utility, getting children outside into the fresh air, getting them playing, getting them active, all outweighs that risk. And to find that they are risky and they should be removed is just would be bad for society. So I mean that's fairly settled. In considering the engineering evidence, the manufacturers of the monkey bars put forward very strong evidence saying that they are captured by the relevant EU standards as they're meant to be. They were assessed by an independent third party and certified as compliant with the relevant EU standards. And that was significant, the judge saying, well, where are you compliant with the EU standards? you've discharged to a certain extent your duty of care, and there can be no defect with the product, which was interesting. It also went on and said the evidence from the other defendants were that the playground was inspected when it was first installed. It was inspected on a weekly basis. There was a second accident where another child actually fell off the monkey bars and injured himself. And following that, the playground was actually closed down for a period of time while further inspections were carried on. And ultimately it was reopened with no changes. And we should all of that considered, the occupiers there had clearly discharged the duty of care, and the court found for the defendants, in fact, awarded costs against the plaintiff in that case.
Yeah, it's great to see the social utility of areas like playgrounds, seeing the benefit of such a practical approach being taken by the court. And as you said, these cases are defendable if you have the maintenance records and the inspection documents and the risk assessments. You know, if you retain those documents from the outset, you have a good chance of being in a good position to defend these cases. Yeah. The final case worth mentioning on this area is O'Driscoll and the Irish Providence of the Bon Secours cistern. So in that case, the plaintiff was an adult entrant. He was taking a shortcut across the defendant's premises and he came across a gate that was locked. And he decided to climb the gate. He jumped from the top of the gate onto the ground and he broke his leg. It was quite a significant injury that actually required surgery. And Miss Justice Egan in that case acknowledged that while it was, a well-worn shortcut, it was totally unforeseeable for the defendants that a grown adult would try to climb over it and jump from the top. So in that case, she found that, or she emphasised, I suppose, that adult entrants need to take reasonable care for their own safety, and she dismissed that claim. So I think that's just another good example of the courts reiterating that the balance between occupiers and entrants is getting the benefit of a bit of common sense, I think. To summarise, Richard, do you want to give the key takeaway for the audience of this particular area? Yeah, I mean,
there's a fair bit there. Really quickly, I suppose, always remember, as I mentioned at the start, the balance of probability on the plaintiff to establish that there was a danger on the premises. I'd say it goes further. They have to establish this danger was an unusual danger. There's no set rules of what makes a usual or unusual danger. It'll depend on the property, what was being carried out, what was being done then. They have to establish that as a result of the danger, they suffer their injuries and that the occupier breached their duty of care. So always approach from that way. It's up for the plaintiff to establish these when you're assessing it. In all the cases that I've discussed, there was very strong evidence put forward by the defendants to support that they discharged their duty. There were inspection records. In relation to the campsite case, I discussed evidence put forward that when the campsite was being designed, they'd gone over to France, the architect and the owners on a business trip to kind of assess caravan parks all around France, and it was built to best practice. So really important to have all the documents to be able to support the argument that you've discharged your duty of care and to retain them.
Great. I think that's some really good advice. So we might now jump over to Sarah, who's been very quiet over there in the corner, and move on to some retail defamation. As I mentioned earlier, we've seen a significant increase in the number of defamation claims coming across our desks over the last year. What do you think about that, Sarah?
Yeah, no, I would agree with that. I've definitely seen an increase, particularly in the last 12 months, of these claims coming across my desk. The good news, I suppose, is that they are defendable. And I think with the rise in the number of cases, we're seeing, an appetite there for retailers and clients to push these cases on and defend them in full before the courts. So a claim for defamation, just taking a step back and how it can arise in a retail context. In order for a plaintiff to succeed in a claim for defamation, they have to show that there was publication of a statement that had the potential to injure their reputation. So in a retail setting, that can arise if a member of retail staff or a security guard makes an approach to someone, maybe makes an accusation that they've stolen an item, or whether a transaction has gone through. So retailers are perfectly entitled to protect their property, ensure that items aren't stolen from their shelves. It's just the manner in which the approach is made, the language that's used, that can sometimes give rise to a claim for defamation.
Yeah, I've certainly seen myself, a lot of these claims seem to be arising out of the use of self-service checkouts, or staff members maybe not being aware of the protocols around approaching, asking for receipts, and perhaps over publication of that kind of approach. So you just mentioned there that the claims are defendable. What are the defences that are open for retailers in this area?
Yeah, there's typically two defences, I suppose, that we would try and rely on. The first, and the defence that we'd most commonly rely on, is the defence of qualified privilege. So that's set out under Section 18 of the Defamation Act 2009. And in a nutshell, it effectively allows an individual to make a statement, even if it turns out that it was inaccurate or untrue, provided that at the time they made the statement, they had an honest and reasonable belief that it was true. So in a retail setting, that could arise if a cashier is working on a till, she sees an individual walk by the till with a full bag of shopping, unaware that that shopping may have been purchased in another shop, but held an honest belief that items may not have been paid for. In those circumstances, provided, as you say, the approach was made in the necessary way, the defence of qualified privilege would apply to those circumstances. The other defence, and we wouldn't rely on it as much as the defence of qualified privilege, is the defence of truth. So it's a total defence to any claim for defamation if you can prove that the allegedly defamatory statement was in fact true. So in a retail setting, that would come about if an individual was accused of shoplifting, but had actually been caught red-handed shoplifting. So if you had, very clear CCTV footage showing someone take an item, place it in their bag, and then an approach is made by a security guard or member of retail staff, whoever it may be, but then you can consider relying on the defence of truth. You just need to be careful. If it's unsuccessfully pleaded, there is the risk of aggravated damages being made against you. So you just need to make sure that you have the witness that was involved in the incident. Ideally, if you have CCTV footage that clearly shows the incident, then that's a situation where you could consider that defence.
Yeah, as you said, I suppose there is a risk of aggravated damages if you don't have those witnesses available. So the last thing you want to do is arrive to court and not have the witness that's going to back up your assertion that the statement was true. Then you're essentially doubling down on the defamation and making the situation worse for yourself, because you're going to end up with aggravated damages on top of the award. So that's a good point to bear in mind. Qualified privilege is preferable to truth. How do these claims play out in the courts? Have you seen any cases over 2024 that you can elaborate on?
Yeah, so because the majority of retail-based defamation claims are taken in the circuit court, we don't always have the benefit of written judgments. So sometimes it can be difficult to assess how judges are dealing with these cases and what level of rewards are being given. We did have an interesting case last year. It was a case that went before Judge Jennifer O'Brien in the circuit court. It was Mark Kelly v. Boyle Sports. So the plaintiff in this case had been accused of ambiguous bet taking. The defendant had published a notice on their internal webpage notifying staff of that suspected behaviour. An employee of Boyle Sports subsequently took that notice and published it on his Instagram feed, and the plaintiff took a claim for defamation. So the defendant, Boyle Sports, sought to rely on the defence of qualified privilege, arguing that they were entitled to protect their property and they had suspected the plaintiff had engaged in that behaviour. However, it turned out at the trial that they weren't able to put forward any documentary evidence to support the belief that they had that the plaintiff had engaged in that activity. And Judge O'Brien, in discussing the defence of qualified privilege, made it clear that you have to have the documentary evidence to support the defence. And in the absence of that, found that Boyle Sports had acted with malice, and where malice has been inferred, the defence of qualified privilege has to fail. So the defendant was unsuccessful in pleading qualified privilege. In relation to whether or not they were vicariously liable for the actions of the employee who published the notice on social media, Judge Jennifer O'Brien said that fell outside the scope of his normal duties with Boyle Sports and found that the defendant wasn't vicariously liable. So the judgment's well worth a read. It talks through the defence of qualified privilege, how it can apply in a retail setting, and then just reiterates the importance of having the necessary evidence to be able to rely on the defence successfully.
I think it is really important, like as you said, you want to ensure that you have the documentation and the witnesses to make sure that you can back up the qualified privilege plea. And there's no point to getting to court and realising that, you do have an exposure because you're going to be found with some malice in bringing that defence.
Yeah.
What was the level of award made in that case, or what's the general level of awards made in defamation cases?
Yeah, so in the Mark Kelly case, the court made an award of 7,500 for general damages. That's a case that I would consider, I suppose, on the more serious side of things when you look at, as you say, the self-scan checkout type defamation cases. So it was interesting to see that that was the level of damages that was awarded. There also was a case reported in the newspaper recently involving a minor plaintiff. So the minor had been stopped by a security guard. An accusation of theft had been made and a physical search had been carried out on the plaintiff. And that was successfully ruled down in Dublin Circuit Court at 6,000 for general damages. So it's just interesting to know kind of the level of awards that have been given by judges.
Yeah.
To bear in mind.
It definitely is worth bearing in mind. I mean, it's not a huge level of damages, 6 to 7.5 grand or less for the less serious ones. You might have an award of 500 to 1,000 euros for, you know, a wrongful approach, asking for a receipt and over publicising whatever it is. But if you have an award of 500 euro, what you really do need to bear in mind is the cost element of these claims. So particularly when you're considering your reserves at the outset of a case, you know, you need to bear in mind that a 500 euro exposure for damages could lead to 30 grand cost bill or more if it goes to trial. So I suppose our main advice on that area is to reserve accordingly if you do intend to run a case to hearing. And if you don't intend to run it to hearing, if you do identify exposures from the outset, or you're missing witnesses, or you don't have the CCTV footage, it's worth making all-inclusive settlement offers to try to deal with it in a, I suppose, as concise way as possible and deal with it that way. You explained that defamation, the term defamation means a statement that was made in public that tends to, you know, undermine a person's reputation. How do the courts deal with claimants who potentially have a tainted reputation or a damaged reputation already, and how do you establish that information when you're dealing with a case?
Yeah, it's interesting, and it was actually before that issue was before the High Court recently in the case of Berkefee Media House. So the plaintiff in that case had taken a claim against the defendant for articles that had been published in the Sunday Independent, and while the court, you know, accepted that a number of points raised in the article were in fact inaccurate, the plaintiff at the time was already in the media for contempt of court, and the judge found that the article didn't have the effect to damage his reputation, so the defendant successfully defended that. For retail-based claims, when the claim comes into us, we'll raise a notice for particulars, and in that notice for particulars, you're entitled to ask under Section 43 of the Defamation Act whether or not a plaintiff has ever been convicted or acquitted of any offences in the state. So if replies to particulars come back in and, you know, a plaintiff has previous theft charges, that's obviously hugely beneficial and something you need to consider, maybe pleading in your defence whether or not they had a reputation that was capable of being damaged. I know I had a case last year where between the two of them, the plaintiffs, I think, had about 45 previous convictions. So when replies came in, it was an easy enough decision to push those cases on to hearing.
Definitely a very easy decision there. Do you see any developments or changes coming down the tracks in this area in 2025?
Yeah, I think with the rise in the number of cases, it's obviously frustrating for retailers, and I think pressure was starting to come on the government to bring about some change in the area of defamation law. So last year we had the publication of the Defamation Amendment Bill 2024, and that sought to amend the defence of qualified privilege. So the courts have said, you know, on numerous occasions that asking somebody for a receipt or whether or not their transaction has gone through is not in and of itself defamation. And the proposed bill sought to put that on a statutory footing. So I'm not sure whether it would have any major impact in practice, but I mean, it's always helpful to be able to point to statute in defending any claim. Having a look at the programme for government, there is a section that's titled Tackling Retail Crime, and in that the government have committed to tackling the issue of retail-based defamation. So we'll just have to keep an eye on it and see what steps they're taking over the next 12 months or so.
And finally, on defamation, what would be your top tips for the audience in dealing with these types of claims?
Yeah, I think the Mark Kelly case made it clear, the importance of retaining evidence. For defamation cases, CCTV footage is just so important. When the claim comes in, if you have CCTV footage, it's either going to corroborate the plaintiff's version of events, and if that's the case, then you can, make a decision as to whether you want to dispose of that case at an early stage, or it might totally contradict the plaintiff's version of events, and then you know where you stand, and it's plough on and defend the case in full. Like with any claim, an instant report form, witness statements, ideally retail staff should have undergone defamation training, and if we can get copies of those records. And then just to push the cases on for hearing as soon as possible. The nature of retail, there's high turnover in staff, and you don't want to be 2 years down the road, as you said, with no witnesses available at a hearing. So to try and get them listed as soon as possible if you have a good defence to the claim.
Yeah, I absolutely agree. And essentially, like if you have active litigation, the key takeaways are that damages may be nominal, but you do need to bear in mind the cost exposure from running a trial and maybe having a nominal award made against you. So all-inclusive settlements are the preferable route. If you do have any exposure, you need to try to identify exposures early. So have your consultation early, bring in your witnesses. You may have the best witness statement in writing, but when you get the witness into the room, they may not remember anything, or they may not be willing to cooperate. So it's best to find that out at the outset, and then you can make a informed decision on how to run the case. And the final point to bear in mind, as Sarah mentioned, is have retail defamation training and ensure that staff are aware that, of how to make an appropriate approach and how to not over publicize. Because I think that sometimes the approach can be perfect, but it sometimes gets a small bit out of hand in levels of voices that you can nearly see on the CCTV footage. So having all of that awareness, you're in a good position to defend these types of claims.
Yeah.
Now we might move on from defamation and have a chat about personal injury guidelines, and we'll put Richard back in the hot seat for this. So what developments have we seen over the last year in the personal injury guidelines?
I think the one development that we really need to talk about is the draft guidelines that have been approved by the Judicial Council and are now moving forward to the Minister for Justice and to the Oireachtas to be passed. And the draft guidelines have proposed a 16.7% increase for all types of general damages, all types of injuries across the guidelines. And that is being justified or driven, according to the Judicial Council, as an inflationary increase, and they're looking at the harmonised index of consumer price, or the consumer price index, to justify that increase, that 16.7% increase in general damages across the personal injury guidelines. A second, I suppose, another headline is the top award for personal injuries damage. The very top award was catastrophic injuries, has gone from 550,000 to 642,000 euros, so almost €100,000 increase there for the very, very top level. And we discussed the concept of proportionality. That does drag up all the other awards beneath it with it as well, because that's one of the benchmarks you look at when you apply the concept of proportionality. So I think that is the biggest change for the draft guide, the publication of the draft guidelines.
Yeah, and this is, you may not be able to answer this, but it's probably the $1 million question. When will they be enacted?
I'll give it a go. You'll probably be asking that question in a year's time. It's difficult to say. As I said, they have to be passed by the Oireachtas. That's because of questions over the constitutionality of the Judicial Council, and that any questions over its constitutionality is cured by being passed by the Oireachtas. So they are going to be passed. So the next question is, will the draft guidelines be a priority for this government? And they have been criticised by various sectors that it's kind of a backward step increasing general damages. We've done so much work to try and get them down, to bring them in line with other jurisdictions. So it's going to wait and see really again whether it'll be a priority of the government or not. I suspect it mightn't be, but I could be wrong.
We'll wait and see.
Wait and see.
Will these guidelines be retrospective? Will they apply to active cases ongoing at the moment?
And I'll try and give a definitive answer on that, which is
Great.
which is new for me. No, there won't be retrospectives. Section 100 of the Judicial Council Act 2019 provides the guidelines can only be relied upon are only there once they are enacted and once they come to force. So we saw that with the current guidelines that it was April 2021 when they came to force, and only claims issued after that you use the guidelines. Claim before that was the Book of Quantum. So we could be left with a scenario. I think a few people have old Book of Quantum claims hanging around the desk. So you have those for assessing general damages. You have the current guidelines and then you have the new guidelines if and when they are enacted. So at the moment they won't have retrospective step unless Section 100 is amended.
The new guidelines.
The new guidelines. I'm going to get confused.
And since the guidelines came into force, I suppose we've seen a lot of narrative around how multiple injuries with the uplifts and the dominant injuries, how that's actually calculated by the courts. Has there been any change in that discussion over the last year?
I'm going to say there hasn't been any, there has been a lot of discussion about it and maybe clarity about how you apply this concept of proportionality. But proportionality isn't a new concept. It's been around before the guidelines. And that's essentially that awards of damages shouldn't overcompensate a plaintiff, and they must be fair to the defendant as well. A lot of defendants, a lot of people disagree they are, but they're meant to be proportionate and fair to the defendant. And that concept of proportionality has been around for a long time. It's referred to in the current guidelines, and it'll be referred to in the new guidelines, the draft guidelines. That concept is referred to. But we have seen clarity. There's the Zagensky case, there was Collins as well, both for the Court of Appeal, that re-emphasised this importance that there's not overcompensation where there are multiple injuries. And that's where lots of small injuries add up and a plaintiff gets overcompensated because there's temporal overlap to the pain and suffering they've had. And that shouldn't happen.
Yeah.
So there's kind of various ways you can tackle it. It's a discussion, but not a new concept.
Mm-hmm. I think it was well illustrated by Mr. Justice Coffey, actually, in the Keogh v. Byrne case, where he kind of essentially said it's not a mathematical formula to implement. It needs to be more of a holistic approach to, looking at all of the injuries as a whole, the temporal overlap, and as you said, the proportionality, and making sure there's no undercompensation or overcompensation of the plaintiff. Yeah,
and there you kind of refer to a two-step process to make sure a plaintiff's compensated for all the injuries. And then you have to kind of step back and look at that overall award of damages, and is it consistent with, as I said, the highest award and award for other injuries under the guidelines? Is it consistent in proportion to other awards made by the court for similar injuries? So it's kind of a two-step process. And it's not a mathematical formula, but often where there are multiple injuries, there's this figure now of you reduce what we call the secondary injuries by a third. And that's kind of the figure that people are landing at. But again, you might say more of an art form than a science.
So I think it's fair to say that the guidelines are something we will be keeping an eye on over the next year.
Yeah.
So now we might move on to 2025 and where we see trends happening or what we're going to be keeping an eye on over the next year. I might start with you, Sarah. What do you think will be developing in 2025?
Yeah, not necessarily a development, but a trend I think we saw at the latter half of last year was that we are getting hearing dates a good bit quicker. Particularly in the Circuit Court in Dublin, we're finding that hearing dates are coming out within 2 to 3 months, which is good news. Similarly, in the High Court, judges are available and they're getting through the list. So 2025 might be a good year to get some of those old cases that have been hanging around a while and get them pushed on for a year.
Yeah, exactly. And Richard, what do you think? Any predictions?
Very loath to give predictions because hostages to fortune down the tracks. What I have looked at is kind of some reports that have come out last year and kind of the trends in the volume of litigation, personal injury litigation that we were seeing at the Injuries Resolution Board and that we're seeing at the High Court. So around September last year, the Court Services published their report for the previous year. So these are 2023 figures. And essentially civil litigation across all the courts, District Circuit and High Court has increased. Personal injury litigation has increased a small amount in 2023. Leaving aside medical negligence, just pure personal injury litigation has increased a small amount. So still an upward trend there from 2023. Then if we look at the Injuries Resolution Board published a report this month, which got a lot of media attention, and that solely looked at public liability claims. It didn't look at employer liability claims, it didn't look at garment compensation claims or RTAs, road traffic accidents. And so that report compared 2023 as a year with 2019. And the highlighted figure was a 40% reduction in the number of claims being referred to the Injuries Resolution Board. So essentially the number in 2019, there were a little over 8,000 claims referred for assessment of public liability claims. And in 2023, there was 5,795 claims. Very I've written down that referred. So I mean, that's a significant increase. What we've seen kind of when you look at the figures of 2022 and 2023, the claims have been around, and yeah, 2022 and 2023, they've been around about just under the 5,000 mark. So are we seeing a plateau there? Or we're going to start seeing it creeping up slowly for these public liability claims? And it's a wait and see. If I was to make a prediction, I'd say we're kind of plateauing there for a year or two.
Mm-hmm. And do you have any industry specific examples of or any statistics?
Yeah, so in that report I was just talking about, was published about 2023, again looking at public liability claims. Look here, claims in relation to cafes, hotels, and restaurants, when compared to 2019 are halved. So these kind of the occupier liability claims we discussed earlier on. For shops and stores, which we all deal with, claims are down by 44%, according to the IRB statistics. Sports and athletics, they become more recreational. Occupiers liability section 4 claims, they're down 38%. The only increase was in residential care institutions, where claims were up about 22%, but that has been put down to claims in relation to COVID and COVID infections in those places.
And do you have any information on employer liability or motor liability claims from those reports? Yeah,
so we can compare the first half, I'm jumping in years, if we can compare the first half of 2024 with the first half of 2023. Employer liability claims between those two halves of years are down 5%. Public liability claims between those two halves of years down 8%. So we've seen decreases there. Motor liability claims compared from the first half of 2024 to the first half of 2023 are actually up 2%. And what's interesting, we're talking about the guidelines and the effect they may be having. According to IRB, the average award in the first half of 2024 compared to the awards the first half of 2019, which would have been on the Book of Quantum, the average award is now down 22% to €18,700.
Okay.
One more thing. We've got
to stop your statistics, but
I'll leave you, but it'll come as no surprise. We're seeing an increase in awards for psychiatric damages and for special damage. But I think we all know that already.
Yeah. And I'm going to speculate, I suppose, a small bit and ask you, what do you think the reasoning is for the decrease in the employer liability and public liability claims?
Oh, there's a fair bit there. One reason that people are putting forward is the COVID lockdowns, that less people were out and about during COVID, during the restrictions, and people less out, less accidents, less claims. I think that reasoning has kind of been washed out a little bit. I mean, we're about 2 years beyond the most restricted COVID restrictions. So you look at 2 years on statute of limitation. So that reason should be washed out. Is there a change in claim culture? I'd like to think that we're benefiting from our approach and strategy in picking the claims to fight and running them and getting cost orders against plaintiffs with strong defences and assessing claims and settling the other ones early as well. And maybe that's paying off as well.
Yeah. I also think companies are getting more risk conscious, I suppose. They're ensuring that their training is up to date. They're carrying out their risk assessments. They're ensuring proper maintenance and fault reporting in order to avoid accidents happening in the first place. The HSA actually published their report last month in January for 2024, and that found that there was a decrease. I think there was 33 work-related fatalities in 2024, and that's a decrease from 43 in 2023. So I think they're really positive figures and potentially have an influence on the level of claims for employer liability, certainly. And hopefully we'll keep an eye on that for the next year and may see a further decrease again. Sarah, do you have any thoughts?
Yeah, no, I would agree with what yourself and Richard have said. I also think there's maybe better public awareness around claims these days. You know, there's been a few headlines that have caught everyone's attention. You know, most people would be familiar with the plaintiff's claim who was dismissed for caught on social media throwing a Christmas tree. So, you know, defendants now are carrying out very thorough investigations on plaintiffs, whether that's by social media reports or surveillance, and where they have strong evidence. I don't think defendants, are in any way reluctant to push those cases on and get them heard before the courts.
And put their Section 26 applications for exaggerated claims to the court as well, and hopefully get the claim dismissed.
Yeah.
So finally, we have a few minutes to get to Dylan, and I don't think we can end the webinar without mentioning the data breach claims and Dylan in the Supreme Court last week. So I might hand back to you, Richard, for a quick overview.
Yeah, I'm conscious of the time we're on, so I mean, we could do a whole hour on Dylan as well.
Maybe we will once.
Maybe we will after the Supreme Court decision is out. But it really, really brief. I think we all know that under the GDPR, under that Protection Act, that but for breaches of the acts, a person could bring a claim for material and non-material damages. Essentially, material damages, your out-of-pocket expense that you've lost out on. While non-material damages isn't defined in the acts, but it essentially has been pleaded in various ways. And in Dylan, it was pleaded that what was the background of the case very briefly, the plaintiff alleges that there was a data breach when Irish Life sent out just some letters and a policy to the wrong address in relation to him. He said it was a data breach claim, brought the case in the circuit court, pleaded that he suffered distress, upset, anxiety, inconvenience and loss. I mean, and that was kind of the totality of his pleas in terms of damages that he suffered. And the circuit court said, no, that is a personal injury claim. A claim of that needs to be brought under the personal injury process, which involves making an application to PIAB, or the Injuries Resolution Board, as it's now called, getting authorization, and then issuing your summons. So the case was dismissed. It's been appealed to the High Court. The High Court assessed it and said, upheld the circuit court's decision and said, no, that is a personal injury claim that should be brought. Interestingly, that the High Court didn't consider whether distress and anxiety amounted to a recognised psychiatric illness, which we all know you need to recover damage, you need for recovering damages for personal injuries action. And now last week it was heard before the Supreme Court. And essentially that will affect how these cases are pleaded for non-material damage, where they're looking at distress and anxiety, and whether it needs to go through the PIAB, but now the IRB process.
Mm-hmm. And it'll be interesting to see how the Supreme Court approaches this requirement for injuries board authorization. I mean, if there is a requirement for these types of cases, it could, I suppose, have an impact on how defamation claims, for example, are pleaded. So it's definitely something to keep an eye on, not just for those, that deal with data breach claims, but, a lot of areas outside the personal injuries realm.
Yeah, it is.
Affected.
Yeah, it is. That's interesting, because that was one of the questions the judges posed at the Supreme Court hearing, is what could be the knock-on effects in claims for trespass to the person or defamation, where it's not traditionally, it's not now considered a personal injuries action, and it doesn't go through the PIAB process and the authorization, everything that involves in terms of getting medical reports and potentially putting plaintiffs on risk where they don't accept PIABs or IRBs assessment.
Hard to get that into your head.
It is. I'm very old-fashioned.
Yeah, that's all really interesting, and certainly something that we'll keep an eye on over the next couple of months. And I'm conscious that I promised that we'd have some time at the end for some questions. So we might just have a look at some of those now. So first one I might give to Sarah. What about the risk of aggravated damages if you plead Section 26?
Yeah, so you mentioned Section 26 earlier. So that's an application that can be brought under the Civil Liability in Courts Act 2004. So it allows a defendant to make an application to the court where a plaintiff has given false or misleading evidence. You do need to be mindful that an award of aggravated damages can be made if that application is unsuccessful. However, if the application is made correctly, I don't think defendants need to be as worried about aggravated damages as they may think. In making the application, it can't just be made because a plaintiff has said they attended their doctor on one date, but actually they attended on a different date and they give evidence on that. That's not necessarily material to their claim. So it has to be something substantial. If you have a social media report that says they're skydiving every second weekend and they give evidence.
The dream.
Yeah, they give evidence to say, I can bear these trees. Yeah, exactly. you know, that's something when you can, you know, properly ground an application in section 26. And if the application is made correctly and on the right basis, I don't think there's the risk of aggravated damage.
I'm seeing a good few questions here dealing with costs, particularly circuit court costs. So is there any sign of costs coming down this year? I think that's definitely the $1 million question. Richard, you might.
I was hoping I was
take
in the
away.
hot seat for that one. I mean, there is talk of district court costs. I mean, circuit court costs coming down. We're talking about Dublin here. We'll have to wait and see. What I'd like to see in this year is cost differential letters getting a bit more bite when they for the courts. I mean, the guide, as we've to go on with the guidelines again, we've spoken, but they've been around now for a number of years. People know what jurisdiction claims should be brought in. And I think where claims are unnecessarily brought in the circuit court and the award of damages is in the circuit court level, and you've served a cost differential letter in the circuit court, I think that should have more implications in terms of costs. I know we have seen it in the circuit court at the end of 2024, at least one case I know. I think there's a few more where an award of €7,500 was made, cost differential letter was served, and that has significant cost implications as well. So I suppose that's what I'd like to see, as well as the overall kind of assessment of costs coming down.
Yeah, I think we all issue them, but seeing the effect of them would be fantastic.
Be great.
Yeah, and there's certainly been whispers of the cost coming down in the circuit court, but whether we'll see that this year or not, I suppose remains to be seen.
Yeah.
Do you think I or B mediation will reduce claims going to litigation? I think the short answer to that is no. I think it's a really cost effective option for clients, and sometimes it can get rid of, you know, the more straightforward cases, but I can't see it having a major impact on the claims for multiple injuries or the more significant and ongoing claims that, you know, will ultimately need to go to litigation to get further medical reports and go through the process. Deep.
Yeah, I mean, I suppose I disagree a little bit with you. It's got another brave move, but but I think for the very low level injuries where recovery has taken place within a year, the mediation probably does have some role to play. For more serious injuries, I can't see it having a role to play, because when we think the mediation takes place, it'll be within a year, possibly 2 years of the accident. And where injuries haven't settled by that stage, how can you assess and award damages?
Mm-hmm.
And how can it be advised? So for the low level claims, for the low quantum claims, kind of the district court, low district court claims, hopefully it will.
Yeah.
Hopefully it'll take care of those nice and early. But for anything more serious where injuries haven't settled, I'm not seeing it being reducing those claims.
Any thoughts on plaintiff solicitors appointing medical experts?
Yeah, that's well timed, because we mentioned that in our review. There was a case, again, some experts could talk about for ages, but really briefly, there was a decision in 2024 that was critical of a plaintiff solicitor referring his client to a medical expert. I mean, that's contrary to the Law Society guidelines. That's contrary. The decision was, and it was contrary to previous High Court decision where they said, like, there's no issue with a plaintiff solicitor or anybody referring a plaintiff to an expert to get an expert report. The decision, which just escapes me right now, is a little bit more nuanced and more concerned how the expert had been briefed. And in that case, the plaintiff had recovered and admitted she recovered within 6 months. And it was Judge Jimmy said, well, like, but the plaintiff said they'd recovered in 6 months. The GP doesn't need any expert report. Why are you referring a plaintiff to an orthopedic surgeon? Interesting in that case, and which more important than any expert report, is the medical report simply repeated the description of the accident and the plaintiff's symptoms. It didn't go that step further in diagnosing and into causation. And again, the judge there said, well, look, it's a very limited help to the court. And in fact, the result of that report, according to the judgment, was it undermined the plaintiff's evidence a little bit, where there was a swearing match between the plaintiff and the defendant in relation to how it was an RTA, how the accident occurred. So when you're facing any expert report, it's more important to look at how the expert was briefed, what's been said in the report, and not who referred it. Very briefly, I know in our previous webinar, Aidan Gleeson, consultant in emergency medicine, made the point that where it's the treating doctor they have difficulty sometimes where there's a relationship of trust and a treating doctor's relationship with a plaintiff, but they might be able to call a plaintiff out where they might feel injuries are exaggerated or something like that. So sometimes it is better to get an independent
I
report.
think that was a really interesting point made by.
It was, yes.
Yeah.
That's something, yeah.
We have time for one more. If the guidelines aren't enacted, can courts still apply inflation? So if they don't come in.
Okay, so if the general, yeah, if the
new guidelines presumably don't come in the next couple of months, are the courts still going to be applying the figures?
So if it's not enacted by the ROCT, will we see a creep of inflationary increase in general damages? I don't think I've heard of it, and I've seen it happening and referred to. I don't think the courts can. Really quickly, the guidelines and the Judicial Council Act are very clear that the court must apply the guidelines. There's no mention of inflationary increases. In Delaney, the Supreme Court would kind of almost hit a higher bar in saying that the guidelines can very rarely be departed from. So I don't think we can now suddenly inject this concept of inflation into personal injuries, and I don't see the connection.
Yeah,
so I'd say no, they shouldn't be.
Yeah,
and it should be pushed back on.
Yeah. Okay, unfortunately, we are running out of time, and I'm conscious that everyone's given up their lunchtime to join us. So thank you so much for joining the webinar today. We tried to cover a good variation of topics, so we hope you found it interesting and you got something out of the last hour. At the end of the webinar, you will receive a link. So just click on the link and fill out the feedback in order to get your CPD. And if we didn't reach your question, please feel free to reach out to Sarah, Richard, or myself, and we'll be more than happy to discuss your question or the topics in further detail. Thank you again for joining and enjoy your day.